Imagine sitting in an immigration detention center surrounded by guards, waiting to be put on a plane out of the United States, only to discover that you were never supposed to be deported at all, not because of a simple paperwork error or a missing form, but because you were actually a U.S. citizen the entire time. It sounds impossible, but it has already happened. During recent immigration enforcement operations, dozens of people who had a legal right to be in the U.S. ended up in ICE custody. Some were lawful permanent residents, some held valid visas, and in several alarming cases, U.S. citizens themselves were caught in the system. And now a major change has taken place that could affect how immigration enforcement operates nationwide. Leadership at the Department of Homeland Security has shifted. The previous DHS secretary is out, and a new one is taking over. That might sound like just another political headline, but for millions of people in the U.S., green card holders, visa holders, undocumented immigrants, and even naturalized citizens, it could have very real consequences. When DHS leadership changes, policies can change, enforcement strategies can change, and priorities can be rearranged quickly. Depending on how those priorities are applied, it can affect how officers in the field operate, how cases are evaluated, and how assertively enforcement actions are pursued. So the real question isn't just who the new DHS secretary is. The real question is what this leadership shift means for you, your family, and anyone currently dealing with the immigration system. Could enforcement become more targeted? Could visa and green card applications face tougher review? Could internal priorities at DHS change how immigration cases are processed or investigated? And most importantly, what should people actually be doing right now to protect themselves as these changes start to take effect? Because by the end of this video, I'm going to walk you through the key shifts that could occur under the new leadership and the practical steps people should begin taking immediately if they want to stay prepared in today's immigration environment. Hi, I'm Olivia, and on this channel, the USA Guide, I break down current immigration developments, policy changes, and real-world situations so you can see clearly what's happening and how it might affect you. Immigration law can feel incredibly overwhelming, especially when news about enforcement, policy shifts, or new leaders in government starts spreading online. People hear headlines and start worrying without really knowing what those changes mean in day-to-day life. My goal is to take complex developments inside the immigration system and explain them in a way that is simple, practical, and useful, so you can make informed choices about your situation. Because immigration is not just about forms or legal language in Washington, it shapes real families, real futures, and real opportunities. A single shift in enforcement priorities can influence which cases get closer scrutiny, what kinds of violations immigration officers focus on, and even how benefits like green cards or citizenship applications are reviewed. That's why this latest leadership change at DHS is something people should not ignore. With a new secretary stepping in, we could see changes in how immigration enforcement is structured, how resources are allocated, and how agencies like ICE and USCIS function going forward. In this video, we'll look at what this transition could mean for three specific groups: green card holders, people who have overstayed visas, and naturalized or U.S.-born citizens who may unexpectedly come into contact with enforcement. We'll talk about possible policy directions under the new leadership, three major shifts that might affect immigration enforcement, and then I'll walk through several practical steps you can take right now if you want to protect your status and avoid unnecessary problems with the system. Later, I'll also share a real case that shows just how complex immigration enforcement can become, even for someone who legally qualified as a U.S. citizen. Once you see how that situation played out, you'll understand exactly why preparation and awareness matter more than ever. To understand why this leadership change matters, you first need to understand how powerful DHS really is. It's not just one office making rules. It oversees a large network of immigration and national security operations across the U.S. Immigration and Customs Enforcement, ICE, is under DHS. U.S. Citizenship and Immigration Services, USCIS, which handles green cards, work permits, and citizenship applications, is also under DHS. Customs and Border Protection, CBP, responsible for border enforcement and ports of entry, is part of DHS too. So when DHS leadership changes, it doesn't just affect one agency, it can influence the direction of immigration enforcement across the entire country. Policies can be updated, enforcement priorities can be redefined, and resources can be shifted. Officers in the field can receive new guidance about which violations to prioritize and how aggressively to pursue them. That's why this transition is so important. In recent years, immigration enforcement has already become more intense in ways many people hadn't experienced before. Raids have increased in some regions, detentions have expanded, and officers have applied long-standing rules with much stricter enforcement than in some earlier periods. In many cases, the laws themselves haven't changed the way they're enforced has. That difference is critical. There are immigration rules that have existed for decades, but were not always used as forcefully. Now those same rules are being applied more strictly. For example, travel rules for green card holders have always existed, but extended stays outside the US are now getting closer attention than before. The same is true for visa compliance, tax compliance, and documentation in family-based petitions. These are not always new laws. The intensity of enforcement is what has increased. That rise in enforcement has also been controversial. Reports have shown that a number of US citizens were detained in the course of immigration operations. In some situations, people with legal status were temporarily held because officers believed there might be immigration issues. Several reports noted that more than 100 US citizens were detained during enforcement actions over a certain period. In a small number of rare but very serious cases, individuals were removed from the country before their status was verified. Cases like this triggered intense public debate about how enforcement should be carried out. Some argued tougher enforcement was necessary to strengthen the system. Others said operations were too aggressive and that mistakes were happening because of pressure to act quickly. Regardless of political views, one thing became very clear: the immigration system was under enormous strain. Agencies were expected to enforce complex laws in millions of cases, while also responding to political demands, public criticism, and logistical challenges, often all at once. When a system is under that level of pressure, mistakes are more likely. Documents can be misread, status can be misunderstood, and people with a legal right to remain can sometimes be pulled into enforcement actions anyway. This environment is one reason leadership changes at DHS draw so much attention. When a new secretary takes charge, they often review enforcement strategies, operating procedures, and internal priorities. That doesn't always mean enforcement becomes softer or harsher overnight. Sometimes it means enforcement becomes more organized, more focused, and more deliberate. That brings us to the new leadership stepping into the position now. Senator Markwayne Mullin has been chosen to lead DHS, and his background gives some indication of where the department could be headed. Mullin has built his political profile around national security, border issues, and government oversight. He has repeatedly supported stronger border enforcement and has argued that immigration laws should be applied more consistently nationwide. That outlook suggests that under his leadership, the focus might not be on reducing enforcement, but on restructuring how it operates. In other words, enforcement could become more coordinated, more targeted, and more systematic. This point matters because many people assume leadership changes automatically mean more or less enforcement. In reality, the bigger shift often happens in how enforcement is planned. Instead of broad, unpredictable sweeps, agencies might start concentrating on specific types of cases, specific violations, or specific regions. That could mean immigration authorities become more deliberate about who they investigate, how they conduct operations, and which cases are at the front of the line. For undocumented immigrants, that could mean more planned, intelligence-based operations. For visa holders, it could mean closer checks on visa terms and compliance. For green card holders and naturalized citizens, it could mean deeper review of documents, travel history, and immigration records in certain situations. None of this means enforcement will just disappear. In some ways, a more organized system can be more effective than a scattered one. When strategies are clear and coordinated, agencies can work with better communication and more specific goals. That's why many immigration lawyers, policymakers, and community groups are watching this leadership shift closely. The real impact won't just come from the announcement of a new secretary. It will come from the policies, priorities, and operational changes rolled out over time. So people naturally ask, who exactly is leading DHS now, and what could his leadership mean for the future of immigration enforcement? Markwayne Mullin is not coming in as a longtime immigration administrator. His background is in politics, security discussions, and a strong record of supporting tougher border measures. Over the years, he has stressed the need to apply immigration law consistently and strengthen the government's ability to manage unauthorized entry. That matters because leaders tend to bring their priorities with them. As DHS Secretary, he'll oversee one of the biggest and most complex agencies in the federal government. DHS manages immigration enforcement, border protection, citizenship processing, disaster response, cybersecurity, and more. Because the scope is so wide, the Secretary's leadership style can shape how money is spent, how officers are trained, and how strategies are implemented around the country. But here's where it gets interesting. When people hear about new leadership at DHS, they often focus on whether enforcement will go up or down. In practice, the more important change is sometimes structural. And based on what we know about the incoming leadership, many observers believe one of the first big areas of focus could be how ICE organizes its enforcement operations. An overhaul of operations doesn't always mean fewer enforcement actions. It can just as easily mean more. What it usually means is changing the way decisions are made and actions are carried out so they are more coordinated and goal-oriented. Instead of operations that look random or disjointed, leadership may push for enforcement that relies more on data, intelligence, and clearly defined priorities. That might involve identifying specific categories of violations to concentrate on, improving coordination between local and regional offices, and using more advanced digital tools and databases to track compliance. For undocumented immigrants, this could mean that enforcement is more focused on people with prior removal orders, certain criminal records, or multiple immigration violations. For others, like green card holders or people with pending applications, it could mean that when they interact with the system, officers are working with more detailed guidance on how to verify status and handle complex records. Even people who have legal status can run into complications if paperwork is incomplete, out of date, or inconsistent. Another part of any serious enforcement restructuring involves training and internal procedures. One critique of past enforcement efforts was that some officers might not fully understand immigration law's complexity when making decisions. Immigration law is one of the most complex areas of U.S. law. There are many visa categories, several pathways to citizenship, and a large number of exceptions and special rules depending on personal history, family relationships, and how a person entered the country. Without strong training and clear guidance, misunderstandings are easier, and in immigration, misunderstandings can have serious consequences. That's why some believe new leadership could place emphasis on better training, coordination, and standardized procedures, with the goal of lowering the risk of mistakes while still enforcing the law. But there's another important reality. No matter who runs DHS, the department operates within broader federal priorities. Enforcement strategies are shaped not only by the Secretary, but also by the administration's overall goals. One ongoing topic that continues to shape policy is what to do about the large number of undocumented immigrants in the U.S., often estimated around 11 million. That discussion influences how lawmakers and agency leaders think about enforcement options. Because of that, it's unlikely that enforcement will stop altogether. Instead, it may become more structured, more data-driven, and more focused on specific targets. That means agencies could rely more on intelligence, records, and shared databases instead of less organized actions. While that might reduce some of the confusion from past operations, it can also mean enforcement is more efficient at identifying people whose status doesn't match legal requirements. This is why many attorneys stress preparation. As enforcement becomes more organized, gaps in documentation or compliance can be noticed more quickly. That leads to another possible shift under new DHS leadership, a broader focus on national security responsibilities within the department and how those affect immigration. Immigration enforcement is only one piece of DHS's work. The department also handles border security, cyber defense, transportation safety, disaster response, infrastructure protection, and coordination among security agencies. When leadership changes, the shift in priorities doesn't only touch immigration, it can also change how resources are distributed across all of these missions, and that can have indirect effects on immigration. For example, if DHS increases investment in cybersecurity, that could lead to more powerful digital tools for analyzing immigration data. That could mean stronger identity verification, deeper background checks, and more automated reviews of records. If DHS focuses more on emergency response through FEMA, some resources could be temporarily redirected when major disasters hit, which might slow some immigration services. Border security almost certainly will remain a central focus. Under leadership that emphasizes border control, resources may go into new border technology, surveillance tools, and operational support. That information often flows directly into national immigration systems used by multiple agencies. All of this ties into a third potential change: shifts in immigration funding and processing priorities. DHS leadership helps decide how much funding goes to enforcement, border projects, national security, and immigration services. If more funding goes to border infrastructure or national defense programs, less may be available for agencies that process immigration benefits. USCIS, which handles green cards, work permits, asylum, and citizenship, already deals with heavy backlogs. If resources are strained further, processing times could increase. Employment-based categories like EB-1, EB-2, or NIW petitions require detailed review. If officers have larger caseloads or fewer staff, those reviews can take longer. Family-based petitions can slow down. Marriage-based green card cases may face more questions or longer waits if officers are directed to look more carefully at documentation. Naturalization applications might take more time as background checks and record reviews are expanded. None of this means programs are going away. The laws are still in place. But it does mean that timing and scrutiny can change based on how DHS uses its budget. When resources are tight or more oversight is added, officers may spend more time per case, request more evidence, or run more checks. That's why it's important to understand that your immigration outcome depends not only on your personal documents, but also on how the system is functioning in that moment. Leadership decisions influence how crowded the system is and how deeply it looks at each file. If this explanation is helping you see how leadership and policy shifts might impact enforcement and processing, this is a good time to stay connected so you don't miss future updates. Immigration rules, enforcement strategies, and application procedures can change faster than most people expect, and understanding those shifts ahead of time can make a big difference. Many people only look into immigration rules when a problem has already started. But the best protection usually comes from knowing the rules and trends early, so you can prepare. That's why discussions like this matter. Once you understand how the system works and where enforcement priorities are moving, you can make better decisions about documentation, travel, and future applications. To show just how important that preparation can be, I want to share a real case that reveals how complicated immigration enforcement can become, even when someone is legally a U.S. citizen. This case shows how details in someone's immigration history can completely change the outcome and how easily those details can be missed in a pressured system. A man got into legal trouble after being accused of a felony. The charges were serious enough that immigration authorities became involved, and he was eventually placed in IC detention. At first glance, the case looked similar to many others: a person with criminal allegations, an immigration history to review, and the possibility of deportation depending on the result of both the criminal and immigration cases. But when attorneys reviewed his file carefully, something stood out. He had originally entered the U.S. as a lawful permanent resident with a green card. That alone doesn't automatically protect someone from removal in all criminal situations. But there was another key detail in his family history. His mother was a U.S. citizen, and at some point when he was still young, she had naturalized. That might sound minor, but under immigration law, it can be crucial. There's a legal concept called derivative citizenship. Under certain conditions, when a parent becomes a U.S. citizen, their minor child can automatically become a citizen as well, without filing their own separate naturalization application. One of the key conditions is the child's age at the time the parent naturalizes. If the parent becomes a citizen before the child turns 18, and the child is living in the U.S. as a lawful permanent resident, the law may automatically grant the child U.S. citizenship. The legal team began reconstructing the timeline. When did the mother naturalize, and how old was he then? If the dates aligned, it would completely change the situation. Instead of being a green card holder facing deportation, he would actually be a U.S. citizen who should never have been in immigration detention. Proving that meant gathering records, doing legal research, and racing against the clock while he was still in custody. When the documents finally came together, the truth was clear. His mother had become a citizen before he turned 18, while he was living in the U.S. as a permanent resident. Under the law, that meant he had automatically acquired U.S. citizenship at that time, even though he had never applied for naturalization on his own. Legally, he had been a U.S. citizen for years without knowing it, but he was still in immigration detention, facing removal. Once attorneys confirmed this, they informed the family. The news was both a relief and a shock. On one hand, the law supported his citizenship. On the other, they realized that unless the mistake was corrected quickly, a U.S. citizen could be deported. The case shifted from defending against removal to urgently proving citizenship before a deportation could take place. What happened next showed how stressful these situations can become. Once someone is in removal proceedings, the system can move very fast. People can be transferred between detention centers, scheduled for hearings, or even put on flights with little warning. In this case, he had already been denied bond, even though there was no final criminal conviction. Immigration law allows judges to base detention decisions on allegations or perceived risk in some situations, even when criminal charges are still pending. That meant he stayed in custody while his status was being reviewed. During this time, he was transferred to another facility. For a period, it wasn't clear where he was being held. Transfers like this are common. People can be moved between states as facilities manage space and logistics. But when transfers happen in the middle of urgent legal work, they can make it harder for attorneys to act quickly. Eventually, it was discovered that he had been moved to a center in Miami and was already being processed for deportation. The urgency increased. The legal team submitted documentation showing that he qualified for U.S. citizenship through his mother. They provided her naturalization certificate and proof that he was under 18 at the time. Under the law, that evidence should have been enough to at least pause removal while the claim was reviewed. However, officials initially replied that an additional form would be needed to formally recognize the derivative citizenship, Form N600, which is used to get an official certificate of citizenship for someone who acquired it automatically through a parent. That requirement created a serious problem. N600 processing takes time, and he didn't have much. The lawyers explained that the existing documents already proved citizenship and that deporting him before considering that evidence would be a major error. They argued he needed to remain in the U.S. while the claim was evaluated. As his removal date approached, the case became a race against time. Motions were filed, evidence was sent, and legal arguments were made that deporting him would violate the law because by then he was already a citizen. Finally, just one day before he was due to be put on a flight, the removal process was stopped. The evidence was reviewed, and the deportation order was halted. In the end, he was recognized as a U.S. citizen who should not have been in deportation proceedings. This story shows how complex the system is. Immigration law has many layers, exceptions, and special rules that even experienced professionals can struggle with. Officers handling enforcement cases often work under time pressure and heavy caseloads. When systems are strained, crucial details can be missed. In this case, the key detail, derivative citizenship, could easily have been overlooked, which would have resulted in a citizen being removed from his own country. Cases like this are one reason people hope leadership changes at DHS will bring stronger training, better communication, and improved internal procedures. When officers have better access to legal guidance, more thorough training in complex immigration concepts, and clear steps for confirming status, it lowers the odds of life-changing mistakes. DHS manages millions of cases involving people from all over the world. That job demands not only enforcement, but also accuracy, fairness, and a real understanding of how complex immigration rules can be. These cases also highlight another key lesson. Many people assume that once they get legal status in the U.S., they never need to think about their immigration history again. In reality, your history can affect you years later. Details about how you entered, when your parents naturalized, what forms were filed, and how older cases were handled can all become important again if immigration authorities review your record. That's why preparation and documentation matter so much. And in the current DHS environment, with leadership focused on structure and security, it's even more important to take proactive steps to protect yourself and your family. Looking at everything we've discussed, the DHS leadership change, the possibility of more structured enforcement, shifting security priorities, and real cases where people with legal status were still caught in the system. It becomes clear that today's immigration landscape demands more preparation than in the past. For many years, some immigration rules existed mostly on paper and were not strictly enforced in practice. Now, enforcement systems are more connected, databases are more advanced, and agencies review cases more carefully. That doesn't mean everyone is suddenly at risk of losing their status, but it does mean you shouldn't assume your situation is automatically clear without the right records and planning. This is especially true for three groups who interact with the system a lot: green card holders, people who have overstayed visas, and naturalized citizens with complex histories. Green card holders have permanent resident status, but it can still be questioned under certain conditions, especially after long trips abroad or when legal problems arise. People who overstayed visas face a higher level of risk because their authorized stay has technically expired, so any contact with enforcement can escalate fast. Even naturalized citizens can occasionally face questions if past immigration steps weren't fully documented or if records contain unresolved issues. That's why preparation is more important than ever. There are several practical things you can do right now to reduce risk and avoid unnecessary complications. First, keep your tax records accurate and up to date. Tax compliance matters more in immigration than many people think. When you apply for benefits like green cards, work permits, or citizenship, officers often review tax returns. Inconsistent or missing tax filings can raise questions about honesty, financial responsibility, or even potential fraud. In serious cases, tax problems can lead to legal issues that affect immigration status. Making sure your taxes are filed correctly and fixing any past errors is one of the simplest and most effective steps you can take. Second, be careful with international travel if you're a green card holder. Long trips outside the U.S. can create issues when you try to re-enter. Permanent residents are expected to treat the U.S. as their primary home. Spending long periods abroad, especially trips of more than 6 months, can lead officers to question whether you've maintained your residency. That doesn't automatically mean your green card is taken away, but it can lead to extra questions and review. Officers may ask for proof that your real home is still in the U.S., like job records, housing, or family ties. If those connections aren't clear, things can become complicated quickly. That's why many attorneys recommend that green card holders avoid extended stays abroad unless they have strong documentation and, in some cases, tools like re-entry permits. Third, if your status or application is based on marriage, understand that evidence matters more than ever. Marriage-based cases are being reviewed more carefully to make sure relationships are genuine. In the past, some couples submitted limited evidence and were still approved. Now, officers may look more closely at whether the marriage is real. That means you and your spouse should be ready to provide solid proof of your life together: joint accounts, shared leases or mortgages, photos, travel records, joint insurance, and more.